comprehend the nature of the proceedings against her. Do they understand they're in court, what the charges are, who the judge and lawyers are? And they must also be able to consult with a lawyer with a reasonable degree of rational understanding to assist in their own defense. This is about their current ability to understand and participate. If a defendant is found incompetent, the proceedings are typically paused, and the defendant may be committed for treatment until competency can hopefully be restored. You can't constitutionally try someone who is incompetent.
Let's talk about grand juries. They often operate in secret, which leads to a lot of mystery and misconceptions. What rights, or maybe lack thereof, do defendants have in grand jury proceedings, and why are they structured that way?
Grand juries are fundamentally different from trial juries. They are primarily investigative bodies, designed to determine if there is probable cause to issue an indictment, a formal charge, not to determine guilt or innocence. As such, a defendant has very few rights in the grand jury process itself. They have no right to present witnesses, confront or cross-examine the witnesses presented by the prosecution, or introduce evidence at a grand jury proceeding. The prosecutor essentially runs the show. The proceeding is conducted in secret, with no judge usually present, and the decision to indict does not have to be unanimous. Often just a majority vote is needed. This secrecy is intended to protect witnesses and prevent targets from fleeing. It's a sharp contrast to the public trial rights guaranteed by the Sixth Amendment. Interestingly, while a defendant has a right to be present at most stages of the trial, they have no right to be present during the grand jury's deliberations, or even when evidence against them is being presented, unless they are called as a witness.
So, witnesses who are called, do they get a lawyer in the grand jury room? That seems like a significant lack of protection if they're being questioned under oath.
That's correct. Grand jury witnesses generally have no right to have counsel present in the grand jury room with them during questioning. However, and this is a key practical point, witnesses typically may leave the room to consult with their lawyers outside the room if they need advice on whether to answer a particular question, perhaps based on the Fifth Amendment privilege against self-incrimination. Also, reflecting their investigative function, grand juries can consider evidence that would be inadmissible at trial, such as illegally obtained evidence, remember the exclusionary rule doesn't apply here, and hearsay evidence to decide whether probable cause to indict exists. This allows them to cast a wider net in their investigation.
What about errors? What if there's racial discrimination in selecting the grand jurors? Does that invalidate the indictment?
Yes. Intentional racial discrimination in the selection of grand jurors violates the Equal Protection Clause and will result in the overturning of the indictment and any subsequent conviction because it undermines the integrity of the process. However, other procedural defects in a grand jury proceeding usually won't lead to dismissal of the indictment unless the defects substantially impacted the grand jury's decision to indict or resulted in prejudice to the defendant. Minor technical errors typically won't invalidate the indictment.
Okay. Finally, in the pretrial phase, what is the state's duty to disclose, often known as the Brady Rule? This seems critical for ensuring fairness before trial even begins.
The Brady Rule, from the landmark case Brady v. Maryland, is a crucial due process requirement. It imposes an affirmative duty on the prosecution to disclose to the defendant any material evidence that is favorable to the defendant. This evidence must be favorable either because it's exculpatory, evidence that suggests the defendant is innocent, or because it's impeachment evidence, evidence that undermines the credibility of a prosecution witness. The evidence must also be material, meaning there's a reasonable probability that, had the evidence been disclosed, the result of the proceeding would have been different. The prosecution's failure to disclose such material, favorable evidence is grounds for reversal of a conviction if the defendant can show prejudice, that the non-disclosure undermined confidence in the outcome. This is a vital check on prosecutorial power, aiming to ensure a fair trial by requiring the state to turn over evidence that could help the defense, even if the defense doesn't specifically ask for it.
All right, we've navigated the pretrial maze. Now let's get to the main event for many cases, the trial itself. And the cornerstone of the American trial system is often the jury trial. This is a fundamental right, but when exactly is a defendant entitled to one? Is it for every single crime?
Not for every single crime, no. The Sixth Amendment establishes the federal right to a jury trial in criminal cases. For the states, the 14th Amendment's Due Process Clause incorporates this right and requires states to provide a jury trial in criminal cases for non-petty offenses. A non-petty offense is generally defined by the Supreme Court as any offense with an authorized sentence of more than 6 months imprisonment. If the maximum possible jail time is 6 months or less, it's considered petty, and no jury trial right attaches. It's important to note that this right attaches based on the potential maximum sentence you could get, regardless of the length of the actual penalty imposed. So if a crime carries a maximum of 1 year, you have a right to a jury trial even if the judge ultimately only sentences you to 3 months. This is a common bar exam distinction.
Okay, so it's about the potential maximum exposure, not what they actually end up getting. Can a defendant choose not to have a jury? Can they waive this right and opt for a bench trial just with a judge?
Yes, a defendant can waive the right to a jury trial and opt for a trial by a judge instead, but usually only with the court's approval, and often requiring the prosecution's consent as well, depending on the jurisdiction's rules. The waiver must be made knowingly, intelligently, and voluntarily. This typically means the judge has to conduct a colloquy on the record to ensure the defendant understands the right they are giving up and agrees to the waiver without coercion.
What about jury size and unanimity? Are there specific constitutional requirements for how many jurors have to be on the panel and whether their verdict needs to be unanimous to convict?
Yes, there are constitutional minimums. The Supreme Court has held that a jury of fewer than 6 members is a denial of due process. So a 5-person jury in a criminal case is unconstitutional. 6 is the minimum allowed. And crucially, after some recent Supreme Court rulings, a, quote, unanimous verdict is constitutionally required of both federal and state juries in serious criminal cases, regardless of the number of jurors, whether it's 6 or 12. Even if you have a 12-person jury, the verdict must be unanimous for conviction. Federal rules typically require 12 members, unless this requirement is formally waived in writing and approved by the court. An interesting exception in federal court allows a verdict by 11 jurors if the 12th juror was excused for good cause, like illness, after deliberations have already begun.
And what about jury composition? Does the actual jury that gets impaneled have to perfectly mirror the community's demographics? That seems impossible.
No, not perfectly. The requirement is that the jury pool, the veneer from which the actual jury is selected, must be drawn from a representative cross-section of the community. The selection process for potential jurors cannot systematically exclude distinctive groups based on race, gender, etc. However, the specific impaneled jury, the actual 6 or 12 people chosen, need not be a perfect representative cross-section. The focus is on the fairness of the selection process, not the final composition. The defendant has standing to challenge the jury selection process based on this cross-section requirement, even without a showing of actual bias in their specific case. To make a prima facie case for lack of a representative cross-section, the defendant generally has to prove 3 things. 1, the group alleged to be excluded is a distinctive group in the community. 2, the representation of this group in veneers from which juries are selected is not fair and reasonable in relation to the number of such persons in the community. And 3, this underrepresentation is due to systemic exclusion of the group in the jury selection process.
That brings us to peremptory challenges, which allow lawyers on both sides to strike potential jurors without needing to state a specific reason. These seem like a powerful tool in shaping the jury. How do they work?
Peremptory challenges allow a party to disqualify a potential juror without showing cause, unlike for cause challenges which require proving a specific reason why the juror cannot be impartial, like bias or relationship to a party. Each side gets a limited number of these strikes. A fascinating point for appeals is that the loss of a peremptory challenge does not violate a defendant's constitutional right to an impartial jury, as long as the jury that ultimately sits is impartial. The erroneous denial of a peremptory strike isn't usually grounds for reversal on its own. The focus is on the impartiality of the seated jury, not on the defendant's ability to use all their strikes. The Constitution allows states to choose how to handle appeals of erroneously denied peremptory challenges. Some use harmless error review. Some might use automatic reversal if the judge acted in bad faith.
But these challenges, while powerful, cannot be used for discriminatory purposes, right? That's the whole point of the Batson Rule.
It's exactly. The 14th Amendment's Equal Protection Clause prohibits the discriminatory use of peremptory challenges, meaning challenges based solely on a potential juror's race, ethnicity, or gender. This rule comes from the landmark case Batson v. Kentucky and its progeny. It's a major area for appellate litigation. The analysis involves a 3-step process. 1. The moving party, the party claiming discrimination, must first establish a prima facie case of discrimination, for example, by showing a pattern of strikes against jurors of a particular race or gender. 2. If that showing is made, the burden shifts to the party who exercised the peremptory challenge to provide a race-neutral or gender-neutral explanation for the strike. Importantly, this explanation doesn't have to be persuasive or even plausible, just facially neutral. 3. If a neutral reason is offered, the trial court must then decide whether the moving party has carried their ultimate burden of proving purposeful discrimination, essentially, determining if the proffered reason was just a pretext for intentional discrimination. The ultimate burden of persuasion always rests with the party alleging discrimination.
That's a crucial mechanism to try and ensure fairness in jury selection, although challenging in practice. More broadly, what does the right to an impartial jury mean, and what are some common issues that arise regarding potential bias?
A defendant is entitled to trial by an impartial jury. This means jurors who are unbiased and capable of setting aside their preconceived notions and deciding the case based solely on the evidence presented in court and the judge's instructions on the law. Claims of juror bias or misconduct discovered after the trial are typically subject to harmless error review. When racial prejudice might be a significant factor in the case, or when race is inextricably bound up in the facts of the case, the court generally must allow the defendant to question potential jury members about their views on race during voir dire, the jury selection process. Also, in capital cases, death penalty cases, jurors who are so strongly opposed to the death penalty that their opposition would prevent or substantially impair the performance of their duties as a juror in accordance with their instructions and their oath can be removed for cause during sentencing phase selection.
And finally, a key rule related to jury trials impacting sentencing enhancement. What's the rule there? Judges can't just add time based on their own findings, right?
Right. This stems from the important Apprendi v. New Jersey and Blakely v. Washington line of Supreme Court cases. The rule is that the Sixth Amendment right to a jury trial is violated when a judge enhances a defendant's sentence beyond the statutory maximum authorized by the jury's verdict based on facts, other than the fact of a prior conviction, that were not found by the jury beyond a reasonable doubt. Essentially, any fact, other than a prior conviction, that increases the penalty for a crime beyond the prescribed statutory maximum sentence must be charged in the indictment, or equivalent charging document, submitted to the jury and proven beyond reasonable doubt. This prevents judges from unilaterally increasing sentences based on additional facts that they, not the jury, find by a lower standard like preponderance of the evidence. It reserves that fact-finding power when it increases the maximum punishment to the jury.
Beyond jury trials, a huge number of cases actually end with guilty pleas, often as a result of negotiations leading to a plea bargain. These are incredibly significant because the defendant is waiving many fundamental trial rights. What are the strict requirements for a valid guilty plea to be accepted by a court?
Guilty pleas are a waiver of core constitutional rights, like the right to a jury trial, the right to confront witnesses, and the privilege against self-incrimination. Therefore, they must be made knowingly, voluntarily, and intelligently, and typically in the judge's presence. The judge plays a crucial role here, conducting what's called a plea colloquy on the record to ensure the plea meets these standards. The judge must determine that the plea is not the result of force, threats, or promises other than those contained in the plea agreement itself, ensuring it's not coerced. Under federal rules and many state rules, the judge must also determine that there is some factual basis for the plea, meaning the judge needs to be satisfied that the conduct the defendant admits to actually constitutes the crime they are pleading guilty to. This isn't about determining guilt beyond a reasonable doubt, but about ensuring the plea isn't completely baseless or made by someone actually innocent who doesn't understand the charges.
And a defendant has a right to a lawyer during this critical stage, right? What if their lawyer gives them really bad advice during plea negotiations? Can that invalidate the plea?
Yes, absolutely. A defendant has the right to competent counsel when deciding whether to plead guilty and during the plea process itself, because it's undeniably a critical stage of the prosecution. Therefore, a guilty plea can later be attacked collaterally, like in a habeas petition, based on ineffective assistance of counsel under that two-pronged Strickland test we discussed earlier. For example, if counsel failed to inform the defendant of the immigration consequences of a plea, or gave grossly incorrect advice about the likely sentence, a plea can also potentially be challenged later for lack of jurisdiction. The court didn't have power to hear the case. Or on other fundamental due process grounds. Example, the defendant was mentally incompetent at the time of the plea.
What about plea bargains themselves? Is there a constitutional right to be offered one, or is it purely a matter of prosecutorial discretion?
The defendant has no constitutional right to a plea bargain. Prosecutors are generally not obligated to offer one, and they have wide discretion in deciding what charges to bring and what deals to offer. Therefore, a plea made in response to a prosecutor's threat to bring more serious charges, if the defendant doesn't plead guilty, generally does not violate the due process clause, end quote, assuming the more serious charges are legally viable. This is considered part of the give and take of plea bargaining. Additionally, during plea negotiations, a prosecutor is generally not required to disclose impeachment information regarding government witnesses or information related to a potential affirmative defense. The prosecution's Brady disclosure duties are typically less extensive during plea bargaining than they are before trial. Finally, a plea bargain agreement is generally enforceable against the prosecutor and the defendant if accepted by the court, meaning both sides have to stick to the terms. But it is not binding on the judge. This means a judge can reject a plea agreement, even if both the prosecutor and defendant agree to it, if the judge believes it's not in the interest of justice, for example. The defendant cannot force the judge to accept a specific plea deal.
Another fundamental trial right is the right to a speedy trial. Justice delayed is justice denied, as the saying goes, and this is crucial for the integrity of the system and fairness to the accused. What protections exist against delays before formal charges are even brought? Can the government just wait forever?
Generally, no. The primary protection against pre-accusation delays between the crime and the filing of charges comes from statutes of limitations. Most crimes have a specific time limit within which charges must be filed. If the government waits too long, the statute of limitations typically bars prosecution altogether, ensuring that stale claims aren't brought when evidence might be lost and memories faded. The Due Process Clause also offers some minimal protection against extreme pre-accusation delays if the defendant can show both that the delay caused actual substantial prejudice to their defense and that the government intentionally delayed the charges to gain a tactical advantage. This is a very high bar to meet, however.
Okay, so statutes of limitations are the main check before charges. What about delays after charges are filed? Post-accusation delays. When does the clock start ticking for the Sixth Amendment speedy trial right, and how do courts figure out if that right has been violated?
The Sixth Amendment protects against unreasonable post-accusation delays. The speedy trial clock starts ticking when the defendant is officially accused, which means either when the defendant is arrested or when formal charges, like an indictment or information, are brought, whichever occurs first. To determine whether the Sixth Amendment speedy trial right has been violated by post-accusation delay, the court doesn't use a fixed time limit. Instead, it applies the flexible balancing test, established in Barker v. Wingo, considering 4 factors in light of the totality of the circumstances. 1. The length of the delay. Is it long enough to be considered presumptively prejudicial, usually meaning approaching a year or more? 2. The reason for the delay. Was it caused by the prosecution, the defense, or neutral factors like court congestion? Deliberate delay by the prosecution weighs heavily against the government. 3. The defendant's assertion of the right to a speedy trial. Did the defendant actively demand a speedy trial, or did they acquiesce in the delay? And 4. The prejudice to the defendant caused by the delay. This includes oppressive pretrial incarceration, anxiety and concern of the accused, and most importantly, impairment of the defense, like lost witnesses or faded memories.
And if the court balances these factors and finds that the right was violated, what's the ultimate remedy? Can they just restart the clock?
No, if the defendant's Sixth Amendment right to a speedy trial was violated, the only remedy is extremely severe. The charges must be dismissed with prejudice, meaning they cannot be refiled ever again. It's a dismissal of the case entirely. It's such a drastic remedy because the courts recognize that once the right is violated, the harm often can't be undone.
Moving to the broader concept of a fair trial, which goes beyond just having a jury or speedy trial, what specific actions or circumstances, maybe involving the judge or the prosecutor, can violate this fundamental right to overall fairness?
The right to a fair trial, guaranteed by the Due Process Clauses, is violated if the judge presiding over the case has an actual bias against the defendant, or a significant financial or personal interest in the outcome, or even sometimes if there's a serious appearance of bias. A judge must be neutral and detached. This right is also frequently violated if the prosecutor engages in misconduct during the trial. This is a really high-yield bar exam topic because there's so many potential ways prosecutors can cross the line and create reversible error. Examples of prosecutorial misconduct that can violate the right to a fair trial include misstating the law or facts to the jury during arguments, talking to the defendant without defense counsel present once the Sixth Amendment right has attached, expressing personal opinions about the defendant's guilt or innocence, or the credibility of witnesses, vouching, making improper or inflammatory remarks about the defendant designed to appeal to prejudice, commenting directly or indirectly on the defendant's failure to testify at trial, which improperly burdens their Fifth Amendment privilege, or, perhaps most seriously, knowingly using perjured or false testimony, or failing to correct false testimony presented by a government witness. The Supreme Court considers the knowing use of false testimony by the prosecution a profound violation of due process that requires reversal if there's any reasonable likelihood it affected the judgment.
That's a lot of ways a prosecutor can unfortunately cross the line and potentially jeopardize a conviction. Now, let's talk about the right to confrontation, the right to face your accuser. This feels like a very basic, intuitive part of a fair trial.
It is, and it's explicitly guaranteed by the Sixth Amendment. At trial, a defendant has the right to encounter and cross-examine adverse witnesses, the witnesses testifying against them, and be present at every stage of trial that would enable the defendant to effectively exercise that right. Cross-examination is seen as the primary tool for testing the truthfulness and reliability of testimony. However, the right to physical, face-to-face confrontation is not absolute and may be overridden for important public policy reasons, but only in narrow circumstances. The most common example involves protecting child victims of abuse from the trauma of testifying in the defendant's physical presence, provided there are other adequate assurances of reliability, like testimony via closed-circuit television, where the defendant can still see and hear the witness and cross-examine through counsel.